This is the final outcome for this case. It has now been dismissed, and the clock for the next steps has officially started. Let's walk through what this means in practical terms. The case is now officially dismissed. District T. Babcock accepted and adopted the recommendation from Magistrate Judge Richard T. Gurley, dismissed the amended complaint and the action, dismissed without prejudice, denied in forma pauperis, IFP. Status on appeal, entry 49 judgment makes it final. That means the case is over at the district court level. The case was dismissed. Not because of facts, not because of defendants, not because of evidence. It was dismissed for failure to comply with Rule 8 pleading requirements, failure to comply with court orders, Rule 41B dismissal. After multiple cure orders, repeated instructions, final recommendation, objections filed, new filings attempted. The judge still dismissed. That tells you the court found the defects were not corrected. His TRO motion is dead. The same order also disposed of the temporary restraining order attempt. That motion is now effectively irrelevant. No active case equals no emergency relief. The appeal clock has now started. This is the most important timing issue. He now has 30 days from April 7, 2026 to file notice of appeal. Deadline May 7, 2026 approximately. Authority, Federal Rule of Appellate Procedure 4A 1A. If he misses that, the right to appeal is gone. IFP denied on appeal. Very important. The order states, leave to proceed in forma paups on appeal is denied. That means he must pay filing fees to appeal or file a new motion asking the appeals court to allow IFP appeal filing fee, federal, about $605. That alone stops many appeals. What happens next? Realistic scenarios. There are now only a few possible paths. Scenario A, he appeals. Notice of appeal to the United States Court of Appeals for the 10th Circuit. Most likely result, affirmation of dismissal. Why? Appellate courts rarely reverse Rule 8 dismissals after repeated cure failures, especially after multiple warnings, multiple opportunities, clear procedural defects. Scenario B, he refiles new lawsuit because dismissal was without prejudice. He can start over with a new complaint. But all the same requirements still apply, and the same defects will likely reappear unless the structure changes dramatically. Scenario C, he files more motions anyway, common in cases like this. Motions to reconsider, motions to reopen, motions claiming technical errors. Most fail, especially after final judgment is entered. The pattern across his cases matters, based on what you've shown. 2021 case dismissed, failure to prosecute. 2022 case dismissed, failure to serve show cause. 2026 case dismissed, Rule 8 failure. That's a repeated procedural collapse pattern, not a merits pattern. The technical filing difficulties letter, entry 47. This came just before dismissal. That suggests he may attempt to argue filing problems prevented compliance, but judges rarely reverse dismissal based on general technical complaints, especially after repeated prior failures, unless there was proven court system failure, not user error. Blunt bottom line assessment. This case is now closed and realistically lost, not because of evidence, not because of defendants, because he never produced a legally compliant complaint after multiple chances. That's the critical failure. Number 1, what to watch next. If activity continues, expect. Most likely, notice of appeal, possible. Motion to reconsider, new lawsuit filing. Claims of procedural injustice. Less likely, acceptance of outcome. If you want next-level analysis, we can now evaluate whether an appeal would realistically succeed, whether refiling would survive screening, or whether repeated filings could risk restrictions like filing limitations. Those are the real next stage risks now.